What are the options for Rahul Gandhi now? Will the fight be legal? Will it be political? Will it be both? Or could Rahul Gandhi choose to say, I will go to jail? There's so much to unpack here as Mr. Gandhi is disqualified as Member of Parliament. Joining us now is a very special guest. We are joined by Abhishek Singhvi. He's one of the best-known jurists of India. He is, of course, also a three-term sitting Member of Parliament, a chairman of the Parliamentary Standing Committee, and also the person who's front-facing the entire response of the Congress party to this issue, along with two other very big cases. The opposition, a joint opposition front coalition, has gone to the court and said the agencies, the CBI and the ED, are being misused. That too is being handled by Abhishek Singhvi, along with, of course, the fight for Uddhav Thackeray in the Supreme Court. Abhishek, it's a pleasure to see you. Let me start straight away by asking you, what is the legal option? Welcome to the program. What is the legal option? This is the law. That's what the BJP is arguing, that everything has gone per the law. Do you first accept that everything has gone per the
law? I don't. There are glaring, indefensible errors everywhere. Let me itemize a few of them without sounding legalistic. First and foremost, let me tell you, Barkha, that you don't have to be a lawyer to know that a first-time offender is never, but never given the maximum sentence. I mean, it can happen. Theoretically, I'm not saying it's not happened, but I have yet to hear of the maximum sentence being imposed for a first-time alleged offender. 2 years is what has been imposed. The maximum sentence for these provisions is 2 years. And 1 year, 11 months, 29 days would not have incurred the disqualification. It is not at all uncommon, even if you are convicted of defamation, which is very rare, to impose punishments ranging from 1 month to 3 months, and 6 months is a rarity. Here it is the maximum 2 years. That's point one. Point two, this is an event which happened in Kolar, Karnataka. A complaint, of course, orchestrated, sitting MLAs of the opposition party, of the ruling party, someone in Bihar, Patna, someone in Ranchi, and this person in Surat for a Karnataka Kolar event. It is precisely for this that Parliament many moons ago made a binding provision by amending the Act called 202, by which any magistrate whom you approach from another state, from a distant area, has to do, obliged to do mandatorily, a preliminary inquiry to satisfy himself whether at all his jurisdiction can be legitimately activated. The 202 point was taken and argued. It is noted in the judgment. Admittedly, no 202 inquiry was done. And this is what happens when things move fast and at lightning speed, which brings me to my third point. Why did these errors occur? This complaint was filed somewhere in 2019, April. In 2021, June, Rahul Gandhi went to Surat, attended the court physically. Inexplicably, although perhaps not so inexplicably, in March, on March 7th, 2022, that is a year ago, the complainant goes to the High Court and gets a stay of his own complaint, saying that the trial court complaint should not go on because of this and that technical point. The High Court grants the stay on 7th March 22, and for 1 year, the complainant is hunky-dory. He's sleeping, the complaint is lying. Nothing happens. On 7th February, Rahul Gandhi gives a very, very fiery speech, an open speech. He makes many, many points about misgovernance in Parliament. And on 16th of February, 9 days later, this same complainant suddenly rushes to the High Court and says, look, I got to stay against my own complaint. Please vacate it, because there is great urgency to hear it. Of course, the magistrate had changed the previous year itself in 2022. The matter comes back on 27th of February, virtually for the first time before this magistrate, in the sense that, it's not really been heard before that. Note the date, 27th February. You have a judgment on 23rd of March. Now, there's no question of a magistrate like that being able to do a 202 inquiry, because, they're speeding along, chugging along after sleeping for 1 year. So that's the third aspect. There are many other aspects. Intent to defame you can hardly be gleaned from a speech of about 3 to 4 pages dealing with unemployment, price rise, scams, misgovernance, and the lot. And you are trying to glean criminal intent to malign, to defame you by misreading that sentence. He did say that how is it that all thieves have this surname? He did not say that all people with this surname are thieves. Now, this is more important than you might think. It was necessary for this gentleman in Surat to claim that it's a defamation of the entire community. Because unless he said that, the first and cardinal principle of criminal defamation is that only the aggrieved person can be a complainant. Now remember, Rahul Gandhi sentenced at 3 names. It's common ground and none of them is a complainant. Not one of them is a complainant. So to maintain a otherwise unmaintainable complaint, this person in Surat, and for that matter, the other person in Patna and the third person in Ranchi, 2 of them very tall leaders of the BJP, and one of them also related to the BJP, say that the persons mentioned by Rahul Gandhi are A, B, and C. A, B, and C have not filed a complaint. I am filing a complaint because I believe that this statement means that everybody having their surname is a thief. Rahul was saying the converse, the reverse, that I find it strange that so many thieves have the same surname.
So do you believe the
that is
verdict?
definitely or not the point.
Are you accusing the judge, therefore, of being poor on law or of being of malafide intent? Which one are you suggesting?
No. Please understand, we have an established judicial hierarchy in this country. The Supreme Court is exempt, and that they say, although every day they laugh with us, they say that we are final, we are right because we are final. We are not final because we are right. Now, a magistrate court is liable to appellate correction by a sessions court, and a sessions court is liable to appellate correction by the High Court. So every day we tell you that you, Madam Judge, have done a wrong judgment, and I'm carrying it to the above court, and that's what I'm saying. These are errors,
okay.
Maximum punishment, no basis of gleaning intent, the sentence being legally wrongly read, the 202 inquiry not being done, and there are many more you will find when the matter goes up.
Are you looking for a stay on suspension? Are you looking for a suspension, I beg your pardon, of the sentence or of the conviction? And I ask you this because the law can be read in 2 different ways. One, that the sentencing of 2 years itself creates a case for an automatic sort of disqualification, which is what has happened with Rahul Gandhi. But a stay on the conviction is a whole different order and could take much longer. Which one are you looking for?
No, there's no option as to which one we might look for. Stay of sentence has been granted by the magistrate himself on the very day that he announced the 2-year sentence. So he granted it in the same order. So that's a given. For 30 days, there is a stay of sentence. And obviously, after that, that 30-day period has to be extended or argued, or otherwise the suspension of sentence has to continue. The law requires a suspension, or as they say, a stay of conviction, not of sentence. So we are not talking of sentence at all. It is not relevant for the purpose of disqualification. It is relevant later on for the purpose of arrest, etc., which we're not talking about now. Today, the law requires that you must suspend or rather stay the conviction. Now, conviction stays are given frequently. Nothing very great about a stay of conviction for a sitting legislator. I must remind you, and I'm doing that case in the Supreme Court, a sitting MP of Lakshadweep got a stay of conviction where his conviction is a murder, for murder, in 3 days later or 4 days later from High Court of Kerala. But that brings me to the related point, Barkha, and I must make a digression. There are many in your tribe who I have no hesitation in saying should be embarrassed to call themselves journalists. And there are many more in my tribe who should be embarrassed to call themselves lawyers. There's a misrepresentation going on since 2 days ago that the Rahul Gandhi and the Congress don't seem to know the law, in that disqualification is automatic. I don't know who doesn't know the law, who doesn't know the procedure, but it's a very sorry state of affairs. Of course, disqualification will follow. My point and the Congress point was a fourth unrelated point. And if you can't understand the nuance, please don't call us names. I don't mean you. I mean the people who've been talking since yesterday. The nuance is this. The question we asked was that, yes, the Election Commission has the power to impose disqualification unless and until I get a stay of conviction. But Power doesn't mean good governance. Power doesn't mean decency. Power doesn't mean balance and reasonableness. If you get a judgment of 170 pages in Gujarati on 23rd, you need to translate, consult your lawyers, draft something and move it. It takes at least 4 to 5 days. There is no tearing hurry for the EC to proceed in 24 hours. The law doesn't say you shall impose a disqualification in 24 hours. So the point being made is a much more nuanced point, which perhaps escaped both my tribe of lawyers and your tribe of journalists, that you should have been a little more balanced in electoral things. Rahul Gandhi is not dying to attend parliament. Let me tell you, Rahul Gandhi has not been allowed to attend parliament. On first, his
But
foreign
why is
chief
he
comes
not?
back,
Why is
says,
he not? Why is he not dying to attend parliament? Why is he not dying to attend
I'll tell
parliament?
you.
He's a parliamentarian.
No,
Why is he not dying to attend parliament?
I'll tell you. I'm making it a comment in irony. He speaks in England. He comes back and he is told that we won't allow you to speak in parliament unless you apologize for what you said in England. He then speaks on 7th February, a very fiery speech. 1/4 of it is expunged and he is purportedly referred to the Privileges Committee. He then speaks outside and you have the amazing spectacle. And I repeat, in 75 years, we may have had 1 or 2 instances. The ruling party gets up and says, we, in front of my eyes, we are disrupting parliament. We will not allow it to go on. Let him first apologize. So you have not allowed him to speak the whole session. The session is now ending. It's been guillotined on Friday, and at the most, we suspect that by Monday, Tuesday, it will be ending. So what's so great about him not speaking for 2 days? That's what I meant by saying that it's maximum 1 or 2 days more. The point I'm making is different. What is your balance, restraint as a constitutional institution, the EC? Could you not wait to allow the man a chance to file an appeal? That's all that is. Disqualification otherwise today has no practical effect, except that he can't speak in parliament for these 2 days.
Given that Wayanad, the seat that Mr. Gandhi represents, has been declared vacant, and that's exactly what you're questioning, that the Election Commission should have been more measured, should have been, allowed some time to Mr. Gandhi. When you sort of go to court to appeal against this conviction, will you also have to appeal against the Election Commission?
Now that's a separate fifth point. First and foremost, the law is very clear. If and when we get a stay of conviction, disqualification must automatically go. If I get a stay of your foundation, your building cannot stand. The only basis of the building is that you have incurred a disqualification conviction. When the conviction is stayed, there is no question of disqualification continuing, point number 1. So a stay of conviction is vital, which is what I've been saying for the last 2 or 3 days. Number 2, it is entirely possible, if you are getting masters in misgovernance, that not only do you announce a disqualification in 2 days, but you go ahead and announce a by-election in Wayanad in 4 days. That would, of course, be the height of misgovernance. But again, as in when you get a stay of the conviction, that has to be stopped. But more importantly, in the case of a by-election, we will be going to court and telling the court that till such time as this matter of stay of conviction is decided, you must stop the by-election. 6th point, that is exactly what happened in the case of this gentleman from Lakshadweep. Exactly. He got a conviction on murder. It took 4 or 5 days to have a stay from the Kerala High Court. In the meanwhile, A, he was disqualified. B, they were in the process and had in fact issued notification for a by-election in Lakshadweep. When he got the stay, the Election Commission said, we will go ahead with the by-election. They said on their own. But remember one thing, it's completely illegal, completely wrong. Despite saying there'll be no by-election, and despite him having got a stay in this Kerala High Court, they have gone to the Supreme Court. And in the meanwhile, this person is not being allowed to attend Parliament because despite a stay of conviction, the Election Commission has not withdrawn its disqualification part. They've said, we won't have the by-election in Lakshadweep, but they haven't withdrawn the notification of the disqualification. One other thing, without wanting to sound technical, it's important for you to know. This is a little technical, but you must know that. I am not conceding there is an alternative view. This, again, your great wizards of the journalistic field and the legal field have missed, possibly deliberately. There is another technical point, which is a debatable point. I'm using words of studied moderation and accuracy. That is that disqualification is not automatic. all that I've argued till now before you is on the assumption that it is automatic till such time as I get a stay of conviction. But there is an alternative view which has to be yet tested, and I'm not relying on it. But I must tell you that view, that since Article 103 of the Indian Constitution in text requires all disqualifications of sitting legislators to be done by the President after a recommendation of the EC, then this must also go to the President and first have a recommendation. The EC, however, from the last 7 years, has adopted a practice that for court-directed convictions, there is no need to go to the President because there is no dispute. It's a court. And therefore, we will not ask the President, we will not give a recommendation. Now, that's a debatable point. I'm not getting into it, but I'm just saying it's not so easy to assume that this disqualification itself is automatic.
But picking up the Lakshadweep example that you've cited, you're basically saying that per you, the law says if you get a stay on Rahul Gandhi's conviction, he should A, automatically be reinstated as a member of parliament, B, there should be no reason to proceed with a by-election in Wayanad. However, having said this, you're saying, despite this being the 2 points of law you believe should be upheld, you are not hopeful that they will be upheld.
No, I'm not exactly saying that. I'm giving you the example of what happened in Lakshadweep. I have no idea what they will do because Rahul Gandhi stands in a special category as far as the government is concerned. As far as other institutions are concerned, also sometimes a special category comes up. What I am saying is that A, there is no way in law that you are disqualified, you, Barkha Dutt, as a legislator on the basis of a conviction. I go and get a stay of conviction and you still continue to be disqualified. I mean, you don't have to be a lawyer or rocket scientist to understand that, because it's obvious, isn't it, that it is the foundation, is the sole ground of your conviction. And I've stated the conviction, so you must be. Now there, the Election Commission is indefensible in that that chap from Lakshadweep is still not formally got a revocation of his disqualification. That's one.
Okay.
Two, a by-election is a further consequence. It's a step ahead. I have to first disqualify Barkha Dutt and then I have to have a by-election in the area from which he was an MP. But that would be ridiculous. Suppose you have a by-election and I win my matter, you'll already have an MP by that time in that by-election. So you'll have 2 MPs, or what will you have? You'll unseat that guy. It's never done. And rightly there in that case, in Lakshadweep, the EC has itself stayed its hand.
Okay. Meanwhile, since we're talking about automatic disqualification, a petition not by the Congress, but by an activist, a lawyer, a PhD scholar has reached the Supreme Court arguing against this automatic disqualification. Does the Congress back this petition? Is the Congress connected to this petition in the Supreme Court?
No, I didn't even know about it till you mentioned it. Somebody sent me a WhatsApp about 5 minutes ago mentioning a PhD student. I have no idea. I'm quite certain it's nothing to do with the Congress. But this is the point I just told you. What he has filed would arise from my 103 point I just told you 2 minutes ago. I told you there is a possible different view, and let me take half a minute to explain that view. The view is that you cannot dilute, modify, or circumscribe the constitutional text. The text is supreme. It is above a statute of parliament. It is above the President of India. It is above the Supreme Court. Even the Supreme Court cannot change it unless they interpret the text differently. Now, the text says all forms of disqualification, and they categorize them, they list them. However, this disqualification is by a court-ordered conviction. So the Election Commission took a view that that reference to a president is required where the disqualification has a disputed question of fact. And there they seek a recommendation. They then added next para in the circular that since a disqualification by conviction is already decided, nothing is left to decide. Therefore, the president doesn't come into it, and we, the Election Commission, need not give. And they've been following this for the last 7 years. So that must be, I'm guessing, of course, I've not seen the petition, what this chap, the PhD scholar, is challenging.
Okay.
Saying that the Election Commission practice is wrongly diluting the text of the Constitution.
Got it. Let's talk about the irony that has been pointed out that I'm sure you're aware of, that in 2013, Mr. Gandhi objected vociferously, controversially to an ordinance that would have, had it been in place today, protected him from the situation he's in. That time, the ordinance was being brought in to protect, it was widely believed, Lalu Prasad Yadav. When he made a big public statement, he being Rahul Gandhi, the UPA government, your party's government, decided to to put a hold on it. Are you struck by the irony?
Well, if you ask me a simple question of irony, there is irony, some irony. But let me explain. First and foremost, what might have happened, what might not have happened, what happened by objection at that time is actually quite irrelevant, number one. Number two, though the irony is there, I think you'd have to be an astrologer or a prophet in that year to know what is happening in 2023, and nobody is claiming that. Number three, Rahul Gandhi's objection at that time was much wider, and I'm not defending or understanding or interpreting it. I'm just telling you what happened. That bill had a different time period. I do believe that some minimal reasonable time, the operative word is minimal time, must be given for a man to exercise his rights. Instantaneous is not valid. But I don't think Rahul Gandhi, of course, he had no ways of, you don't object to a law, support a law on the basis of what might happen to you. And that's the meaning of being bona fide principle.
I mean, yeah, but it would be curious to see if he supports that law today or opposes it. Or
no. What he opposed was the bill generally extended the period he thought unreasonably, before which the conviction would take effect. What we are today wanting and arguing, and I think to some extent the two are harmonizable, is a reasonable period, maybe a week or 10 days, to try your luck before a court of appeal. Now, if just give me half a second more. There were two models. Prior to that striking down by the Supreme Court, the law was that if Barkha Dutt suffered a conviction, her mere filing of an appeal, no stay, nothing, would suspend, and she would continue as she is. The law changed it. The proposed law, that is, which did not come into force, was probably making a 3-month or a 4-month hiatus. I don't remember. I think it's 3 months.
3 months.
Rahul Gandhi's objection was to the length of that 3 months. I don't think he was ever objecting to a short window of a week or 10 days to enable Barkha Dutt to go to a court superior and get a stay. So today we are talking only of this third situation. So there is irony, of course, but I don't think it's that absurd as people are trying to make it up.
Okay, you've spoken, of course, as one of India's top lawyers. Speak now as a politician as well. You're a 3-term member of parliament. Do you believe that politically, Rahul Gandhi could possibly say, I'm not going to appeal. I'll go to jail, make a political statement. Which way is he thinking? Which way is he leaning? You've clearly indicated the intent to appeal this.
Privately, without revealing details, I can tell you that Rahul Gandhi, in private conversation, otherwise, I'm not talking of this case now. There have been other incidents in the past, and I've been very involved in those as well. He is one of those people who's just not bothered about these kind of coercive measures by nature. And sometimes he has to be advised that when he says, if I have to go on a certain principle or point I am steadfast in, let me go. And we have to advise him that these are the nuances. So I don't think that fear factor or even the hesitancy factor or the inhibition factor is even remotely there. If at all, he has to be restrained by those around him. Number two, this is a very hypothetical and in a sense an irrelevant question, if I may say so with respect, because you have 30 days against arrest, The judge himself gives you now, obviously,
yeah, but what if you don't
days,
appeal? What if you don't appeal? What if you don't appeal?
That's what I'm saying. No, but why? I mean, whether he appeals or not, I cannot answer today. That will be a political decision. It will be his decision. It will be a collective decision also. So that will be on the 29th day. It will be relevant. Today, I don't think he's concerned about that. He is the larger issue is, I'll tell you, give me 15 seconds more. Today, till the 29th day, the larger issue is that you are throttling voices in parliament. Why should he not fight the disqualification? I give you 4 examples, and this is the political part, that you are trying this, that he's in a sense been paying the price because he's very outspoken. He speaks of GST, he speaks of China clean chit, he speaks of demonetization, he speaks of this and that. Now, he goes abroad, I told you what happened. He comes here, expunction. He goes here, privileges committee. He goes out and you say, astonishingly, that you will allow parliament to go on till you apologize. Can you ever imagine conditional precedents like apology? Now, this being the case, he has a right to assert that, look, I will seek a stay of disqualification. I will seek a stay of re-election because it's a political thing you are doing. And why should he not? Arrest is something else that we'll discuss after the 29th day.
Do you believe that this is an opportunity to unite the opposition? Because I'm also going to come to the case you're representing for 14 different parties against the investigative agencies, or what you call their misuse. Now, the opposition has been divided. The Congress, for example, is not party to that petition. The Congress has welcomed, for example, what happened with Manish Sisodia in Delhi in the liquor scam case and so on. I'm just giving you examples. Do you believe this is an inflection point? Will the opposition come together? There's been some chatter, should the Congress members of parliament resign en masse?
Look,
What will happen politically?
this is a very important political question. Give me a couple of minutes. I think it's vital, and I'm a great believer in unity, more than unity, in prevention of fragmentation of vote. Let me just tell you the progression of this thinking. And what has happened now is part of my Raipur speech, where the genesis was laid. I spoke on this. Number one, Mr. Modi at his best performance, assuming he does best, at his best performance up to date, has never got more than 39% vote. That means 61 out of 100 vote against him. By simple arithmetic, if you are able to consolidate 80 to 90% of that 61, either Mr. Modi loses or he gets a fright. Now, the 80 to 90% of that 61 remains fragmented. Why? Because of your ego, because of my ego, because of my territorial, regional considerations, whatever. These are ego problems, and we have to understand that. Now, therefore, first point is unity is a given. You cannot resurrect parties in 9 months and make them suddenly winning parties across India. You've got 9 months left. Therefore, unity is the need of the hour. Point two, I said in Raipur, and I'm very proud of the fact that I have, in a sense, achieved a 14-party unity, a legal coalition much before the political coalition. And this legal coalition will possibly be a precursor and a promoter of political coalition. 42 to 43% of the electoral vote is represented by these people across the country. It's just a little less than,
these 14 parties who have petitioned the Supreme Court.
Exactly. And let me tell you, 3 or 4 more would be joining any minute, but there was no time. So we went ahead with 14. So it will be close to 50%. Number 3, this raises a very important issue of basic structure. I put this petition on basic structure. And all this I said in Raipur, mind you. That was the philosophical and conceptual origin. This is the practical implementation in legal terms. Democracy has been held to be part of basic structure 40 years ago. Obviously, it has to be. Democracy presupposes a free and fair playing field, a level playing field. 3 statistics published by the government, not by us, show that there cannot be a democratic level playing field. A, pre-14 and post-14, there is a humongous increase of 1,000% in the number of cases filed by the ED. 1,000%, some 200 to 2,000. And by the CBI, by the way, but particularly by the
1,000%.
Second statistic,
1,000%
yes,
increase.
I've got the figures written in the petition. I may be wrong, but I can give you it's a humongous. Second, of that increase, if you just list all the political cases filed, we're not concerned here about corporate business. You take the 100, 200 political leaders who are in that case. Just take any figure. The admitted figure is that 95% of that 100, 95 out of 100 are opposition leaders. Number 3, equally admitted conviction rate is 3, 4, 5%. Let's say 6%, 7%. Number 4, if you keep on harassing, if you keep on intimidating, incarcerating, coercively harming the opposition leaders at a 95% strike rate, then are you not skewing, making uneven the democratic level playing field, in which case you're hurting basic structure? So we have asked at the end 2 things. 1, a set of guidelines pre-arrest. You will arrest only if 1, 2, 3, 4, and the Supreme Court should lay down fairly clear guidelines. Second category we have asked is that in the event that you do arrest, these should be the guidelines for bail. Let me give you an example of the first category.
I just looked up the figure and it says a 4-fold jump in ED cases against politicians. 95% are from the opposition. So I'm looking
Absolutely.
for the 1,000% figure that you suggested, but this is what I have.
Fourfold is 4,000%, madam.
4-fold. Okay. So it says, let me just read out. No, are we doing this right? 4-fold is not, yeah.
400
it's not 1,000%.
No, it's 400%. 400. If it is 4-fold, what is written there?
Yes.
Doesn't matter.
Okay,
It's
fourfold
probably
jump in ED
400%.
cases since
I have written
2014.
up
Yeah.
there.
Yeah.
And 95% and the conviction rate. Now, the point is, Barkha, that today, take this pre-arrest guidelines. Today, in 95% of those 95% cases, you know how you are getting into arrest? I must come and arrest you because the offense is very serious. That's what they say in every case. What is the meaning of this? Offense is serious means what? You are an under trial, you are an accused, you are not a convict. An accused, according to me, a serious offense is an irrelevant test. The test has to be only a triple test. Is Barkha going to run away? Can't you keep a passport and keep her here? Can't you monitor? In the West, we have GPS, we have even anklets. 2, will you interfere with witnesses, physical or documentary? 3, will you come and I call you for trial or for police interrogation? Provided you take a hypothetical case when all these 3 are satisfied in favor of the accused, why should he be arrested? Now, there is a special provision in the ED for that arrest. We are also saying lay down guidelines for that, because we made a special provision making it more difficult to arrest. It cannot mean that at the interim stage, I must first prove that Barkha is not guilty.
Right.
That can't be. So therefore,
so through this legal coalition, you are looking for Supreme Court intervention specifically, of course, on the issues you've listed. But the political import of this legal coalition in one line is what?
Well, I think the political import of this legal coalition is that everybody realizes the need for unity. I don't think the conviction of Rahul Gandhi defamation was designed to generate unity. We are not here to say that, look, I came here to get a conviction so I could get you united with me. That's not the point. But certainly, it is good to see, and we have publicly acknowledged yesterday at my press conference, it's good to see that people realize that on this, that old saying applies. When I came for the Jews, you kept quiet. When I came for the Christians, I came for the Semites, I came for this. When they came for me, there was nobody to speak for me. So I think there is that solidarity. Secondly, I've been saying this much earlier. There's another irony for you if you want to take that irony. Who was the counsel for Syria? So therefore, me. So it's not, I mean, there are political considerations. I know that AAP and Congress is fighting.
No, that's what I was. That is what I was going to ask you. That this ED case that you are fighting, your own party has not supported the Aam Aadmi Party when the ED has been used against a K. Kavita in Telangana or a Manish Sisodia in Delhi. So that's the irony I was pointing to. And you are representing these 14 parties, but your party is not on the same page as them.
No. I think on this, our party is the lead number one name. It's the first name is INC.
No, I know. I mean politically. I'm saying politically, not legally. Politically.
That's why I'm proud of it, Barkha. This initiative will be a promoter and a pusher and a convergence for that political unity. Mark my words.
Okay.
You have to start small. That's what you are hoping for.
Okay, this big case, of course, is coming up in the Supreme Court. I have 2 minutes left. I have to ask you in the end about the big Shiv Sena case. It's been closely followed. You have fought for Uddhav Thackeray. The one thing the Chief Justice and the judges kept saying to you is, why did he resign before a floor test? If you wanted to make this argument, why did he resign before a floor test?
Well, that's now done and dusted. We await the judgment. We are very satisfied that the court gave us a very, very extraordinarily patient hearing. Number 2, you heard what the Honorable Chief Justice and the brother judges said, but did you hear my reply also? That's the answer. My reply is the answer, which you must just give me 2 minutes, less than 2 minutes to say. I said I'm only making a submission. I'm not saying what is going to happen. It's a reserved judgment. It's sub judice. What they'll decide is. But the argument, I think, has merit. The challenge is to the action of the governor. A, the governor recognizes those who are liable to be disqualified if the speaker is not restrained. B, acting on the basis of the 35, 44, whatever the number of potentially immediately disqualifiable MLAs, the governor calls the whole group. C, acting on the same disqualifiable MLAs, he directs a oath ultimately, and Mr. Shinde takes oath. Now, the argument is very simple. If Mr. Governor is wrong, as the court put directly, that if the governor had no material, And if the governor can decide these issues to preempt disqualification proceedings, then the governor is wrong. Assuming that they find it to be wrong, obviously the Supreme Court first has to find the governor's actions wrong. Otherwise, there's no case for us.
Yeah.
If they find the judgments, if they find the action of the governor wrong, then ask yourself a simple question: how does it? It's a red herring. Whether UT Uddhav Thackeray, as he's called in the pleadings, took or did not go to the houses is actually a red herring. It's only a psychological point. If he had taken, you don't need to. The foundation is the governor's action in calling him. But if that is illegal, if that would be illegal, then his coming or not coming is a psychological red herring. It has no connection.
Well, as you said, we await the Supreme Court judgment on this. All I can say in the end, Abhishek Singhvi, is that any political party would be really relieved to have a legal brain such as yours on their side. So thank you. It's been a riveting conversation and lots of legal fronts open there. Thank you, Abhishek Singhvi. Always a pleasure. I don't know how many balls you're juggling in the air right now between Rahul Gandhi, the petition, the 14-member legal coalition, and the Shiv Sena judgment. We thank you for your time in the middle of all of this. Take care and thank you so much.
Thank you. Thank you so much.
It's great to see you here. Thank you for watching our work. If you haven't subscribed yet, don't forget to click the bell icon and subscribe to Mojo Story and support independent, robust journalism.